Welcome back to WCI-TV, sponsored by Tower MSA Partners. I'm Ed Highland. Thanks for joining us once again. And I'm also pleased to be joined by Sid and Mark. It's Mark Popolizio and Sid Wong, both of Verisk Casualty Solutions. Guys, thanks for coming by.
Thank you.
Let's talk a little bit about something, that I'm hearing some scuttlebutt about, the new CMS reporting requirement, Medicare's new TPOC, WCMSA reporting requirement to be exact. You guys are here to help break it down, and Mark, let's start with you and talk a little bit about from the 30,000 foot level, if you will. But give us some idea what this is all about.
Absolutely. Yeah. Thanks for having us. It's really significant. And from the 30,000 foot view, CMS is going to use the Section 111 reporting process to collect various data points regarding Medicare set-asides related to settlements with Medicare beneficiaries. And the TPOC, for those not familiar with it, total payment obligation to the claimant, essentially a settlement. Okay, so what will happen starting April 4th next year, they will use the 111 reporting system for the first time, this is unprecedented, for the first time to assess what the parties have done and what they haven't done with respect to MSAs as part of work comp settlements. There's a lot more to it from a granular standpoint, and that's why Sid's with us today. Talk to us exactly what's going to go down, what's going to get reported, and how are we at Verisk approaching this?
Yeah, no, it's a great question, Mark. It's the question that everybody's been asking since Medicare has really announced this. As Mark had indicated, it's the first time they've tried to tie together a Medicare set-aside program with the Section 111 reporting. So what's Medicare going to be looking for? Well, they're going to be looking for specific data points to be reported to them. It's going to be the MSA amount, the period of the MSA, whether or not the MSA is going to be funded as a lump sum or an annuity, and if it's going to be funded as an annuity, what that seed amount is and what the annual payments would be. Some voluntary information that individuals can submit as well, it's not necessarily required, is if there's a case control number that's been assigned by Medicare, you can also report that as well. And if there's the MSA is going to be professionally administered, the EIN number of that professional administration company. Now, Medicare indicated that they're going to be taking this information, and if an MSA is going to be included as part of the settlement, they're going to mark their common working file. And once that common working file is marked, that indicates that there's an MSA that can pay primary, and Medicare can therefore coordinate benefits and deny payment for treatment associated with the treatment that may be related to that particular settlement.
And I think that's very important because in one of their releases earlier this year, they talked about this is their exact objective.
Yes.
This is why they've put this new process into place. And I have to say, I'm old enough to remember when the MSA kind of hit the scene back in 2001, which was a significant event. And we've had some other significant events over the years, the passage of 111 itself in 07, the SMART Act in the early part of the 2010s, recently, say, the PAID Act. I would put this new TPOC MSA reporting requirement in that same echelon in terms of its importance and its practical significance in terms of claims and the potential risk that Sid is talking about.
Instead of a question, how about just the word compliance and a question mark?
Right.
Jump.
Yeah, so as Mark has indicated, there's a lot of challenges with respect to this new announcement. So one of them is not just reporting the data itself, which we'll get to a little bit more, but also just being able to collect that data. In my opinion, the industry wasn't really ready necessarily to update their claim systems to be able to intake that information and report it to Medicare. So updating your systems, being able to do that, and then understanding the right data to report to Medicare, reporting it timely, understanding the impact of that to the beneficiary, explaining that as part of the process itself, all that is really important. And over at Verisk, we've really tried to understand some of these challenges and provide avenues to intake the information if you're not necessarily ready yet, to be able to scan settlement documents to pull that information and report it automatically to Medicare. So there's a lot of things that need to be considered as part of the compliance aspects of it.
And yet it's all digital. I mean, it is something that you can compile. You have the resources to be able to do that.
Yeah, absolutely. And that's from the compliance of the reporting. But then there's also just from the MSA program itself, and that's something that we've gotten a lot of questions for. Before, if you didn't report this information to Medicare, Medicare wouldn't necessarily have knowledge of it, right, and be able to enforce on their end. So now that they're going to have this information, one of the questions that we've gotten is, what if we don't report anything to Medicare? Or should we be reporting something to Medicare now? So we're thinking about solutions to present to our clients to be able to economically understand what that exposure is and to be able to report that automatically to Medicare as well.
And I think that leads to, in terms of how do you approach this, right?
Yeah.
So there's a technical aspect. We have a date in April 2025.
Yeah.
But really now's the time, at least from my viewpoint, where insurers should be revisiting sort of their MSA protocols, everything from what are they doing if that settlement with the Medicare beneficiary meets the $25,000 review threshold, what are they doing if it doesn't meet the $25,000 threshold, because all situations involving Medicare beneficiaries are in play. Any type of allocation, whether it's submitted to CMS for approval or not, at play, must be reported.
That's right.
If the settlement falls below the $25,000 threshold, CMS, as Sid said, going to look at that. If you're reporting a zero MSA as part of this reporting requirement, they may look at that. So all these points Sid has talked about from a technical process also, as he mentions, have a protocol component, and now's the time really to start looking at it.
Time, the key word. Time is of the essence
That's
at this
right.
point. Sid and Mark, thank you so much for
our
coming
pleasure.
by.
Thank you.
Verisk is the company, and if you would like some more information, of course, you can always check out the Verisk website.
All right,
In the meantime, this is WCI-TV. I'm Ed Highland, and we are sponsored by Tower MSA Partners.